5, 4, 3, 2, 1. It is submitted on behalf of the petitioner that the gist of the allegation against the petitioner as per the FIR was that this petitioner had enticed the minor daughter aged about 15 years of the informant with an intention to induce her to marry with him. It has further been pointed out that the statement of the victim, who is said to be aged about 15 years old, has been recorded under Section 164 of the CRPC, by which the entire case of the prosecution is falsified. It has further been pointed out that the victim categorically stated in her statement recorded under Section 164 of the CRPC that she had fled away from her house along with this petitioner voluntarily and willingly, with whom she had been in love, and further she categorically stated that she, along with this petitioner, had been staying in a rental house and she wanted to marry with this petitioner when she would become major, and thus the case of the prosecution is totally false and not corroborated by the statement of the victim herself. On the other hand, learned APP, appearing on behalf of the state, opposed the contentions raised on behalf of the petitioner and submitted that the victim is a minor aged about 15 years, and therefore even her consent for marriage is not tenable in the eyes of law to falsify the case of the prosecution. Further, it has also been pointed out that after investigation, the charge sheet has been submitted under sections 363, 366A, 504 and 376(3) of the IPC and under section 6 of the POCSO Act, and therefore this petitioner does not deserve to be enlarged on bail. Having heard the parties perused the record of this case, it is found that this petitioner is a child in conflict with law, and he is aged about 17 years, 1 month and 29 days at the time of the commission of the offense. He is in jail since 27/7/2022. From the statement of the victim recorded under section 164 of the CRPC, it is found that the victim had voluntarily and willingly gone with the petitioner to marry with him when the police apprehended them. The victim categorically stated that she would marry this petitioner when she would become major, and they were in love and living in a rental house, and she had gone without any coercion and pressure from this petitioner, and in this view of the matter, the entire case of the prosecution gets falsified. Learned APP, appearing on behalf of the state, also did not deny the statement of the victim, which has been recorded under section 164 of the CRPC. From the impugned order, it appears that there is no adverse report in the social investigation report, and it is mentioned in the social investigation report that there is a lack of control and proper guardianship over the petitioner, and the petitioner is influenced with the social media and film. It has further been pointed out that there is nothing on the record about the criminal history of the petitioner, and therefore the possibility to come in the association of the known criminals of the petitioner is very remote. Further, in view of the statement recorded under section 164 of the CRPC, the further detention of this petitioner would definitely expose his mental, moral, physical and psychological danger to his life, and therefore in the interest of justice it is found that let the petitioner be released on bail in order to afford one opportunity to him to come into the mainstream of the society. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.